All right, Abusia, ye channel yen san so emo akwaba emra channel so and that's why I bear media judge. Nabusia and the update aba efa eye chama Wontumi, yes. And eye Kevin Ekobadu Taylor of Loud Silence TV aba bonten e de crack that ten a free eye Accra High Court e de aba betwa. Na chese wo kan and someone as wutie and someone Kevin Ekobadu Taylor e de eltudwa na chese chama Wontumi de kia ne ke nsewam na obekwa akobie. We de ma mekasa wa me ma mekasa enye tenten abusuan pese ya ayekọ na yetie ensem a ewo krata ni yes nya Kevin Ekobadu Taylor abusuan ode atudwa anase nia ode atudwa na se yewi a na bomode ya na ya kire ya dwen ewo eye comment section yenko na yentie ensem a chese abebo eye lawyer Andy Apiakubi ene eye ne client a ne din ade eye Chama Wontumi MPP Ashanti Regional Chairman Nina efa nyame ya adoma on the 3rd of July. Abusia we de yenko na yentie. Be media judge be fasa kwanya we so adobi biara ase. Uma yentie ne ekọ so emra sisia yedase.
O client no or high no not court or hobby. Na judge ni kore ni mo chro bibi, mo mianko kan no, and very very important. Or see, the instant application is alien and not a procedural requirement in criminal proceedings. Or say asema apia kubi bejina ne nimu kaye so ono aba court ebe catch record or say sebio enimrem court krampo nim saade no emfaso bia nyansa bia nim eye alien court kran recognize saade no. And okore nim no say counsel herein does not need or say counsel herein or say appear could be time and or can say on ne eye de chairman Wontumi nye adwuma bi no say counsel herein does not need leave of this court to withdraw as counsel or say eye appear could be sebio eni krampo say oye na adwene say oba court abeka kire court say or the chairman Wontumi nye adwuma or say nyanse bi anim or say counsel, which is Apia Kubi. Adio ye no faso bi eni so ensisa bibia. In fact, Apia Kubi experience or one who says sadie we kura wa ye na eye ni muasiema no, because court does not recognize contract between a client and the counsel or his lawyer. No. Now judge in the case no course or say this is an issue between himself and his client. If he chooses by his personal decision to abandon his client at this stage, that will not affect the timeline of the proceedings. See, so on one etu nubo akase on chairman Wontumi nye adwuma bi ma judge ne say saade ne eye Apia Kubi ni chairman Wontumi omwangasa na afa omo ho adwene so omo be yesa na emom ro be say omo nyina te ase say wantwi anasa disagreement ato Apia Kubi ne chairman Wontumi se ontumi nya ne lawyer biemu no o say court we dwumade a ye di no enka ne court enka ne tie court ne de eye ne de eye o say timelines. That means time o ka say o de judgment ne beba on the 3rd of June no ensesa ye Apia Kubi ne lawyer Apia Kubi ne client nyan to kwa say o sesa lawyer na o say court date ayahye no say ye de the judgment beba no sa entokwa ne nsɛmhunu no enka court timelines ho baby a court gina na court gina where any ruling they can't be see end asem no so. Now judge ni kore ni no kan asem bi, and I want to let me see this number 2, right? Okay, judge ni sa kore ni no kan asem bi mama me read emenya bote na medwudwam. Or say, the application is not competent before the court. Assuming without admitting that the application were even competent before this court, the court has taken notice that the lawyer seeking to withdraw has not directed service on his own clients to enable them appropriately respond. Or see, say, opeso oje Apia Kubi ade no kura tum na okase okay de wa ye ne ya. Or say Apia Kubi na nkasa nkwampo no ontumi en serve chairman Wontumi formally. Say ontumi ne chairman Wontumi nye adwuma. Apia Kubi ba court no wan fa krata bia mpo amba court amaka court say court me client way this is a formal document actually say me ne contract no and is easy or say wo apia kubi a wo se wo ne chema wontumi nye dwuma wan fa krata bi mpo ambekire se wo ne chema wontumi no wo ne nye dwuma bi so dia kra na kire se dia wo beka na enya atro because say wo ne nipa no wo official dia contract na say wo ba court krampo a enimrema beka kire se wo ne nye dwuma ya at least weaponize yourself a little bit with some document to prove to court to say even though nyansa bi adim se meba beka kire so bi ne nye dwuma ya krata we krampo to bi dia dance wan fa bibia mba o de won sato wa adwini to and I will toffee abegina has say, one or client in Yejuma. Judge say, as some no NCC so Sabio a waste of court time. Now, Judge ruling American Chirono. Consequently, and yet consequently, Judge and say, in fact, let me see something. All right. Mame, ensure we because when I am marking red, no. Now this is the part I want you to pay attention to. When I am marking red, no. That is from the consequently. And the last one, no. Judge no the judgment or trouble or see. Or can be or see. Consequently, since filing of closing addresses is optional, right now, attaching say, sa closing addresses, no. Enunti na court no entry judgment ni nkwechiri na judge na last ruling no can be or say consequently since filing of closing addresses is optional and not a function of the rules, that is to say there is no provision under the rules compelling a lawyer for an accused or prosecution to file address. See, bro, for the Judge the ruling now here in the last time or money clear or say consequently since filing of closing addresses is optional and not a function of the rules or see written addresses no Sebiana judge focus or yedia assembly we may ba be kire ma adwene me opinion ni in a form of written statement or see optional or say mrabie ni we kire sa de no say yanya yentumi muasem no or say optional opinion of the lawyer inti optional no enya dia say yanya entumi ma judgment number so judge ne last ruling no kan it is an attaching say, let's say the all can on the correct. Nensan to me anka their proceedings, no, and now whatever happened in court now. Sadia Nensa can cry, whatever he will write wouldn't affect the outcome of the case because they are just opinions of the lawyer, they are just lawyers' views on the matter. It does not change the evidence the judge is basing on to write his or her judgment. This is simple. You don't have to complicate this. Atachiamu Jimmy Jema Wontumi. Omo dada MPP for no Jimmy for no. Now judge ne can say me or say there is no provision under the rules compelling a lawyer for an accused or prosecution to file an address. Or say can be or say addresses are optional statements made by lawyers to articulate on the merits or demerits on the case one way or the other. Or see, sir, addresses na attaching say, yam stati enkofa documents in number and or see, those addresses are optional statements made by lawyers to articulate. It is the views of the lawyers, how they see the case. It does not affect the evidence the judge is basing his judgment on. They are just views. They are just opinions. And the judge was saying, those things are, they are on Embrabian words. I say, say, written submissions are, the judgment cannot be brought out. No, or say, optional. You can decide to do it, you can choose not to do it. And we have seen cases where lawyers have come out to say, I have no written submission. I'm done with the case, let the court decide. So whether you write or you don't write, the judge will not even read your submission. 99% of the time, the judges don't read the written submission of the lawyers because the judges don't want the opinions of the lawyers to affect their judgment, which is based on evidence before them. Into some me a judge. Now say me a trauma judgment. I will not waste my time to read an opinion of a lawyer. I will not waste my time to read an article a lawyer has written about the case because I have to base my judgment on the evidence that was provided during the proceedings to make sure I have the right things. The opinion of the lawyer does not matter here, because it's not because of the lawyer that I'm sitting here. I am seated here as a judge because of the evidence put before me, for me to make the judgment based on the evidence. So the court or the lawyer's opinion does not matter. It does not affect the final outcome of the case. In this Atachia said, police Atachia has urged the High Court to defer judgment beyond 3rd July 2026, citing the registry's failure to furnish him with the records of proceedings needed to file his written submission by the court-ordered deadline of 23rd of June 2026. Eya Atachia a obianim se ose achim police ende Atachia oye chairman Wontumi a ogina court because of Samara boy a okoye galamse wo se nsu a and nsu aform. Atachia say ende wakọ court a waka kire court say eya 3rd of July a ebe ya chairman Wontumi na asem no judgment beba no o say wakọ kire court say in fact eye court edwumafo a ye from eye den eye ye from registry for and omo call from the registers or whatever they call them no o se na nka some the information bi ma no na sa information no ni nyina ne time a chairman want to be starting court ensem akoso court nyina na nka say sa nsem ni nyina ya de ma no na okokenkan ansa na wachro ono ano the written submission into because a court registry for no entumi amfasa document na ma nti or catch court ne say 3rd of July judgment na mama judge ne nye onto nhyeda maka che MPP for mo jimi Atachia say before betuma try written statement remember time a chairman Wontumi e change apia kubi okofa Atachia bae no judge ne kan bibi wo court time a ye change apia kubi mebe kan kire mo murefi ye kofa achim police Atachia say ombe chairman Wontumi lawyer no me kan sa judgment ne kire the judge ne kan ye and judge no trust our judgment is not or you're very specific about the timelines. Judge no judgment no can say chairman Wontumi ne lawyer nya problem na so be change e the Atachia ba only problem na Atachia still from that time no to the 3rd of July no order who obey 2 weeks obetumi the actual written submission into on the 3rd July judgment no the beba still from there near year Atachia no order who omre and the Atachia say registry for na document none document Atachia say from the day na chairman want to start court was Samara boy case wo no enkrata ne nsema maka nyina no court mfama no na onya abotrenkin kan ni nyina Atachia yakwasea Atachia say mema judge no on the 3rd mema nfa judgment ma ontu nhyeda adentra from the day na chairman want to start court no sa from that day no ensem om court om chiregu krata so nyina no our court ni nyina ma no na onya abotretena se na okenkan wie na nakoma todie ma na wono achro written submission na ochro submission we ansa na judge no aya na adwene se obe pronounce and asa obeba bontina be ka se judgment ni nie into right now Atachia say yenjai bibia mema judge ni judgment onjai nkotena baby no ono Atachia enye de all ye wie sa na Atachia ka kire Ghana court asiafo now mametwe adwene ko bibi so mebe kan sa judgment na kire day na ye change apia kubi Atachia eko court apia kubi ene chairman Wontumi court eko ka kire judge ni say chairman Wontumi say asesa apia kubi no judge no that day no o ma ruling bi moma yenko ne nsanko kan ruling no eho na bo nsa Atachia omu nyina nim say chairman Wontumi ejimi ene omo dada no mokai sa ruling way I read it on the show mokai sa judgment way this was a judgment I'm reading wa day na eye chairman Wontumi ka say wapamo apia kubi no meka chem say plan na chairman Wontumi mo afa MPP for nyina say on person delay case no on person judge no be read judgment no anytime I go for Tachiaba, now Tachiamba excuse, not 3rd July, no, 3rd June, no, judge didn't me for judgment number. Senator Bayamunim said the following week, no, court to back a break. No more 3 months, no more call election, no more chairman Wontumi. No more catch we as say, almost national chairman NDC, and as I buy a china to almost plan and then the plan and our baby, no more Jimmy. Mokai judgment way. A year in the Superior Court of Judicature, in the High Court of Justice, Criminal Court 4, held in Accra on Monday, the 15th day of June, 2026, before Her Ladyship, Audrey Kokuvi Tay, Justice of the High Court. Now, sir, a year judgment way. Me reading in action, I'm changing which I will say. Judge in judgment of mine, no. Sir, judgment clearly shows to say, judge, you know, written submission in your DBA. A bit may affect the judgment. Written submission. A very vital and a vital. Without written submission, you bet me the judgment abana. Yes. A judge, no, a ruling, no, or can wom. Now, ruling in ye. Before the court raised preliminary legal objection to the application. I have also listened to learned counsel on both sides on objection raised. I have also considered the applicable law. It is the considered opinion of this court that the instant application is a supplicage in the sense that there is no procedural requirement. There is no procedural requirement for a lawyer in a criminal matter to file an appearance. In much the same way, there is no such procedural requirement either under the criminal and other, and other, and other offenses. Act 1960 or Act 1960, Act 30, or by judicial precedent that I have come across, that a lawyer who has decided to cease to act for his clients in a criminal matter must seek the leave of the court to so withdraw. Or say, aseme dene nimuno, and we're ruling no. Aseme dene nima omu pense mu a ende eye apia kubi aba court ebe ka che ono judge say one the client seb your client no high no behind the scenes privately apia kubi be ka che say ono chairman Wontumi nya adwuma bi no say court mramu no ene court awatena aye adwuma no say lawyer odi obi high no de na ba court say sa nipa no lawyer no ne sa nipa ne ja adwuma di a ene de enfa court wo say sa lawyer ne ba court wo be ka kire court say chairman Wontumi ne high me ne kan sika meje e wo kokom and also ne nya adwuma judge ne say onhu wo baby ada say obi high privately na say nipa no pese obe ne lawyer bi ma e wo say wo ba me court ana wo ba Ghana court be ka kire court say ai me be ka kire mo chairman Wontumi ne nya adwuma bi o say emra bi eni ho embra bia ni Ghana kire say wo ne chairman Wontumi wo apia kubi wo ne chairman Wontumi nya adwuma bi ma e wo say wo ba court abeka kire say wo ne nya adwuma bi because chairman Wontumi high wo no na judge ni ho na attorney general ni ho na court of Ghana na eni ho bi. That is a private matter. You are not even supposed to come to court and tell the court to say me ne chairman Wontumi nya adwuma bi. No, a contract na mo sign ya baby a mo sign contract mo nkona mo nkotwam. Inti judge ni say eye ne wanwa say wo apia kubia say bi wo ye lawyer pagini a woni mu mra no ende wa begina court ka kire ne say me ne chairman Wontumi nya adwuma biom na emom no chairman Wontumi akofa lawyer foforo judge ni ruling ni asem o kan ye ni natie dia aka o de kan ho or say even though the respondent has raised other grounds of objection, the objection is sustainable on only one main ground, which is the application by counsel for leave to withdraw from criminal proceedings is not a function of any rule of procedure nor of settled case law jurisprudence. Or see, a woman say Attorney General Krano a raise issue say, there a question Sebio and Fakwem or say apart from Attorney General, Sebio, or raise the issue about the Ecoso court. No, on one gasa crampo who say, court Mremuno Sadi and Yejuma. Yan Sebian say, who are we a lawyer, one of client, my papa muno, and was our back court, because he a minimum client a papa mu.